Hello and welcome to the very first episode of Everything Legal Tech, where today we'll be discussing about what it takes to make a successful legal tech product from the conception to the adoption. As we all know, the market is buzzing with legal tech products, but there are only very few products that make it till the end or really take off, while others kind of fade off. Right, so today joining us is Mr. Bruce Hedin. He is a very experienced person with over 2 decades of experience in research, consultancy, in the intersection of law and artificial intelligence. He has enabled a lot of AI enabled technologies in the legal field. So, Bruce, I'm really glad that you have joined us here on this episode.
And I'm glad to join you also, Swagata. And I'm looking forward to the conversation.
Likewise. Bruce, if you could start by giving our audience a little idea as to how you happen to take up this career, because it's a relatively very new career, right? Career option, and it when there's a shift that has happened from the traditional way of legal working to now where the legal industry is adopting the tech side of it slowly, and there's a mindset shift that's happening. So I would like for you to walk us through your journey and tell our audience that how things shaped up for you.
Sure. Perhaps surprisingly, my academic background way back when was actually in the field of classics. I studied ancient Greek and Latin and so on for many years, but I was very interested in linguistics all along and also in statistics. And as I finished my PhD, I was looking for ways that I could apply those disciplines, linguistics and statistics, in the real world. And around that time, which was around the year 2000, there were a lot of startups in Silicon Valley looking for people with those kinds of expertise. I hooked up with a couple of companies. One was less successful. One was ended up being very successful. And part of the reason it was successful was that it defined the focus of its technology very specifically on the legal demand. And at that point was just the point when particularly tasks in the legal domain, such as document review, were starting to become unmanageable in the conventional ways by humans reading through pages of documents or even looking at images and PDFs. And so we needed a technology solution. And so, that was where I hooked on, and I've always been interested in the law and how lawyers think, as opposed to how scientists think, which were in a way both trying to get to the truth, but by different ways. And I found it a very fascinating interaction between lawyers and scientists in trying to solve this problem, and seeing the legal world go from those days when advanced technology was doing a simple keyword search, right, to where we are now with AI. Has been fascinating, and seeing the different roadblocks along the way and incentives and so on, and negotiating all that to a place where lawyers can make the most out of technology while mitigating any risks associated with it has been very interesting for me.
That's an amazing journey. You really pointed out how the lawyers interact with the technologies, and it really takes a mindset shift that comes along with it. So, and as we are aware, a lot of people have a lot of ideas when it comes to a legal tech product, right? But from your perspective, like you mentioned that you had worked with one company which was not that successful, whereas the other took off. Like, this is something that we usually see. There are products launching almost every quarter, but what is it that makes some products very successful while others kind of do not even take off? More specifically, from your perspective, what do you think it takes to turn an idea which is just at a idea stage to a viable legal product, because I believe not all idea turn into a product, right? So with your experience and from your perspective, what do you think it takes from an idea to go into a viable tech product? Is it the is it solving the pain point? Is it reducing the redundant task that the lawyers have been doing? Like you mentioned, document review, right? It's pretty time consuming when person is reading through huge judgments, which can be maybe summarized by, and we can get the essence through the technology. So what do you think is something that makes a an idea related to a legal tech turning into a viable tech product?
Yeah, it's a very important question. It's really fundamental. It's where you start, and it's good you started our conversation there. And I think that the key is understanding your buyer and your buyer's needs. But that's easy to say, but it's a lot more challenging than you might think, because the legal marketplace, or the marketplace for legal technologies, is particularly challenging. And it's challenging for a few different reasons that I would highlight. One is the buyer landscape. A second is finding the right decision maker. And the third is the culture of legal practice. By the buyer landscape, what I mean is that there are multiple buyers of legal technology. Obviously, there's the law firm. And the law firm may want to adopt a new technology for its own reasons. It has the incentives to adopt. It has disincentives sometimes to adopt. Maybe it's making, perfectly good, it's accruing billable hours without the technology. So why reduce those billable hours by adopting technology? So there's a set of incentives and disincentives that operate within the law firm. And then you also have the corporate client that's hiring the outside law firm, which may have its own team of legal operations within it. And it's operating according to a different set of incentives. It may be focused on cost reduction and reducing budget and so on. That would constitute a win for it within its larger organization. And so those are just two of the buyers. And for a vendor of technology to figure out who are they going to sell to, are they selling to the law firm, and are they adapting their product and their messaging around that product to the law firm and the law firm's needs, or are they selling to the corporate client, in which case they may have a different marketing approach and even a different angle on the technology and how they develop the product. And those are just two of the buyers. And then there are other stakeholders as well. There's the courts that, at least in the context of litigation, may get involved in approving or not approving a given technology and have a say in what is and isn't a viable product. And then there are government agencies. Certainly when you get into questions of antitrust, for example, mergers and acquisitions, you might, that transaction might need to be approved by, in the US, the Antitrust Division and the Department of Justice. In the UK, the Markets and Competition Authority, and so on. So you have not just the law firm, not just the corporate client, but also these other agencies that may have a say into what is and isn't a viable product. So from a technology, from the perspective of the developer of a technology, you have to sort of take all these into account and figure out where your technology is really going to fit in and who's going to benefit, so you can align your technology with the incentives to adopt that technology with a given buyer. And then a second challenge is finding the decision maker. Even within a law firm, at least as most law firms are constituted in the US, they're really collections of partners, and each partner may make his own or her own decisions about what technology they adopt. So selling to one partner doesn't necessarily mean you're selling across the firm. So you have to figure out, well, who's the decision maker? Who's going to give me the most mileage across the firm, so that my technology isn't just adopted by one partner and then it ends there. It actually is able to expand adoption across the firm. And sometimes, some firms will have technology resource groups, technology hubs, and maybe you talk to those people as well. But understanding that dynamic is very important as well. And then, in other countries, law firms have different structures and so on. So understanding those structures are important as well. But that's another layer of difficulty for the developer of a technology. And finally, I noted the culture of legal practice. Lawyers tend to be conservative, they're risk averse. They don't want to be the first to adopt a technology. And certainly going back to the early days of what we called e-discovery, document review technology, it was really an uphill battle to get lawyers to adopt a technology. Everyone wanted to wait for someone else to be the first to stick their neck out and get approval from the courts. But once the courts did get approval, that kind of opened the door to adoption. So that's another, the culture of legal practice. And a couple other things I'd note is also that lawyers tend to be busy and they don't, have time necessarily to read a long technical white paper. And related to that, I don't know how many times I've heard lawyers tell me, I went to law school because I didn't like math. So you have to be able to sell your technology and conceptualize it in a way that's understandable to someone who's not necessarily technically oriented. Some will, they'll love the technical deep dive, but most don't. So you have to be able to figure out how to sell it within, to a buyer who's not necessarily ready for, pages of statistical formulae and so on. So back to your question, putting all that together, I think it still comes down to having a good product that meets a real need, that solves a real pain point, as you said. But the challenge is identifying whose pain point and what that pain point is. And that takes market research and people who really understand the marketplace. It's a lot of groundwork up front.
Right. And Bruce, I can absolutely vouch when you said that lawyers take up law because they don't like maths. So I have done the same. So I can vouch for that. And I have come across lawyers who have taken up law because of the same reason. Right. So I understand. And in my experience of working with the legal industry, what I absolutely agree with is lawyers are extremely risk averse, right? They do not, because it comes naturally, because they are also dealing with a lot of sensitive data or information. So naturally, they do have to be mindful about what kind of technologies they are using or adopting as part of their practice, right? And as you pointed out, that it is very important for someone who is developing a legal tech product to identify who is the right decision maker in that organization, who can have a say and take the decision, right? Having said that, in general, the perspective and the mindset that the legal industry comes from, or what I have seen in my experience of working with the legal industry, is that it is not an easy thing to sell something to the legal team, because lawyers are made to question everything, right? They do question that's part of their job. That's how their minds are wired. They question. So naturally, even when there's a disruption happening at the intersection of law and technology, they do question, which is why most, like you also mentioned, that they use, because they wait for someone else to use it and then maybe adopt it. But what is the one practical tip that you would like to give to the founders who are developing a product? Because it's, again, developing a product is not, it's one thing, but selling it to the legal team and in a way that, kind of builds up the trust, or is something that, can be, the use case can be portrayed. So what is the one tip that the founders should keep in mind while they are selling it to the legal team? Because the mindset that it comes from is, like you mentioned, they do not like taking risk. Lawyers do not like taking risk, so they are not very experimental as well. They would not like to experiment and see. They are very comfortable working in the structure that has, which is why the conventional legal industry has been there. Like, I think legal is the last industry to get disrupted by the tech, right? Other than
Right.
all other industries, the tech comes first. But with legal, it's a very difficult feat. So, what is the one practical tip you would like to give our audience or the founders who are developing a legal tech product?
Well, if I could give two instead of one,
Absolutely, sure.
I would say alignment on use case. Really understand the use case, understand the need in a very practical way, and let the technology follow that, rather than develop a technology and find a use case, that may or may not fit that technology. So understand the lawyer's world, understand where their problems are, and then develop a technology that meets that need, get alignment on that use case. And the other, which is perhaps the more challenging, is trust, because, as you said, lawyers they're by training, they question things. They're skeptical of claims and so on. So you have to be able to provide them with the information that allows them to have a well-grounded trust, not just that the technology works, but of course that the technology does work, but also that the technology will realize the practical benefits that are promised from the technology. It's not just that the technology, for example, accurately extracts the right elements from a contract, or accurately assesses the classification from document, or accurately extracts a timeline from a collection of documents. All that's well and good, but I think if you're thinking about adoption and the lawyer buying the technology, you have to also show evidence that they can trust that will have the practical benefits of saving time, saving cost, improving outcomes in litigation, and so on. So I think you need evidence that the technology works, evidence that the technology will realize practical benefits. I think also along the lines of developing trust, I think if you can provide an early win for the lawyer, that can be very beneficial. In the early days of document review, sometimes we would, the technology was a lot slower then, and so we'd take on a project, and it might be, a long time, weeks, before the lawyer sees a single document. And they're wondering, well, I licensed this technology, now it's still, I understand it has to go through all these training cycles and so on, but it's taking a long time. What we realize, if we could give them a batch of good documents right away and show them that they're going to actually have a tangible benefit, and there's something they can work with right away, whether it's a timeline, whether it's an analysis of a collection or something like that, gives them an early win that allows them to go to their boss, their manager, and say, look, I hired these guys and it's already paying off. Then that helps develop trust. It helps strengthen the relationship that you need. And then a couple other things, I think. One is demonstrate your ability to defend the product, and that may mean, ultimately, if there is a challenge to your to the lawyer's use of the technology, that may eventually get litigated in court. It may be a matter of motion practice and so on. And so if I'm a lawyer and I'm unsure about this product, I want to know who's going to be on my side in court, who's going to be writing my affidavits, who's going to be deposed, who's going to be testifying in a hearing, who's going to really be the expert that backs up my use of this technology. So I'm not out there, on an island by myself. I have an expert who can talk the talk, really go deep if need be, and defend my use of this technology. So I think introducing the lawyer, not on every, the expert doesn't have to be on every call, but at least let them know that there are those substantive experts behind the technology that can defend the product in court if need be. And then the last element, I think, of trust, which is often very important, is relationships with other people. So if it's someone else within the law firm that the person you're selling to has, if there's someone else who has adopted your technology or has some experience with your technology and can be your champion within the organization, then that's helpful.
Right.
Or even if it's someone who's a champion from another organization who can give a call, that helps develop that trust. And sure, the lawyer will still want to do their own road test. They still want to do their own demo. But at least if you can get to that demo, then you're in a position to put your best foot forward. But often the most challenging part is just getting to that demo, getting away from, getting from just a simple sales call to actually putting something in place and showing some results. Because if you can show results, then they can see the tangible benefits.
Bruce, I can't emphasize enough how beautifully you have explained, because even when I asked you the question and you started answering, I had so many questions naturally coming up in my mind that does the founders have a hand in changing the mindset of it? Does trust play a factor? And by the time you ended the answer, all my questions were cleared. It was that beautifully explained, right? So, and the takeaway that I have gotten from this is that first you'll have to solve a pain point, which is very important. Not develop the technology and then try to find your target audience or what it is solving, but rather identify, align with the thinking of the lawyers, because they are already coming out of their comfort zone to adopt these products. So you would have to step into the shoes of a lawyer, demonstrate an early use case, because if we shorten the cycle of proving that this is something which has an actual tangible benefit, I think that is half work done. And lastly is the trust that you'll have to buy, because again, as we know, lawyers by the nature are very skeptical, right? So gaining the trust and being on their side and acting as someone who is helping them with the work rather than disrupting the, it's not about what I understand, it's not about replacing the lawyers, rather than it's augmenting their workflow, is what I understood from this. And that's beautifully said. I think it'll help all the people who are even thinking on the lines of developing a legal tech product. But from what I understand, as you mentioned, getting the demo is very important, but getting the demo and from there the journey becomes even more difficult is what I believe. Because it's one thing, you walk into a law firm or an corporate legal team where you are demonstrating something out of curiosity and everything. They agree to the demo, agree to use it, let's say for a month or something. But what does it really take for them to adopt that as a part of their daily workflow, right? Some tool that they cannot think of not using, going ahead once they have seen the demo. What is that make or break factor that comes in when that helps in the adoption of the legal tech?
Yeah, that's a very good question, because I have had experience of people who are naturally curious and they like to do the demo and they find it fun. And you think, oh, this has gone great. Um, Now they're really going to be ready to buy, and they don't buy because, it's just like, well, that was fun. It was interesting. I'll tell my friends about it at the cocktail party, but I'm not I'm not going to be buying. And that's not what you want as the
Yes,
outcome of
like
a demo.
to make it even more straightforward, how do you make the lawyers or the legal industry dependent on a product that is so useful that they cannot think without it?
Yes. And I think um, that is the way to think about it is, how do you integrate your offering, not just the technology, and we'll talk a little bit about the supporting consulting services as well, but how do you integrate your offering as a whole into their legal practice, into their business processes and legal processes. And I think when it comes to integrating a new technology into a law firm's business practices, or a particular lawyer's business practices, I think there are two things to think about. One is to take a comprehensive view of the ecosystem that the technology is going to live in, if you will. And the other is providing ongoing support for the technology. By taking a comprehensive view, what I mean is keeping in mind that your technology, no matter how good it is, it doesn't live on its own. It lives in a business environment, and it requires things like data that need to be collected from a business. Maybe it's from the lawyer's client, and maybe that data is hard to get. Or maybe, you can get some of it, but some of it's hard to get. Or maybe when you get it, it's not clean, it needs to be normalized. And maybe some of it's not accurate, and so on. So there's a whole set of issues around data, which are really the lifeblood of most AI-enabled technologies. And there's questions of infrastructure. Your technology may require certain IT elements that may or may not be present in the law firm. And if you're expecting them to be there and they're not, then your technology is not going to work as well. And then there's, another component may be people. Do you have the right people with the right competencies in place to be able to operate the technology or assess the results of the technology, and so on. And so all these are parts of the larger ecosystem, as I've called it, that the technology works in. And it's important for you as a vendor to make sure those are in place, because I've seen vendors make the mistake of saying, well, my technology is working fine. It's not my fault that the data isn't being collected, or that the data that's collected isn't clean, or that the client can't get the data that's needed for the technology. It's not the technology's fault. But that doesn't matter. In the view of the lawyer who's adopting the technology, all they see is that they got a bad outcome. And they may even hear you when you say, well, it wasn't the technology's fault, it was the database administrator's fault who couldn't get all the right data together. But in the end of the day, you're going to be associated with a bad outcome. And so you have to have that comprehensive view, and if necessary, have at hand either internally or partner with other vendors, consultants, who can come in and fix those situations when they're not, when the conditions that are required for the optimal use of your technology, when those conditions are not in place. So you want to make it easy for the client and not make the client have to go, oh, well, in order to get, so-and-so's technology to work, I have to go find this vendor who's going to provide some support for my data or provide some IT infrastructure support, and I don't have it in-house. That's a big roadblock. You want to be kind of a one-stop shop and make it easy, and make sure that those sort of preconditions for the effective operation of your technology are met, and met fairly simple, at least from the client's perspective. The other aspect I would say in terms of integrating is providing ongoing support. A mistake that vendors often make is they think once they've made the sale, their work is done. But that just leads to unhappy outcomes. I think there are, I don't have the statistics at hand, but I know even within companies that I've worked with, there's so many cases of software that was purchased and barely utilized. Like of all the features of the software, maybe 10% are actually utilized, or it's utilized only by one group within the company and it's not utilized across the company, and so on. And this is often because the company isn't providing the necessary training and support to help the client get the most of the technology. You might give them enough training just to solve their particular use case that sort of was the starting point and the reason why they considered the technology to begin with. But what you want is to go beyond that immediate use case to a broader, more comprehensive use of the technology, and that means providing the client with consultants who can help them see, oh, well, there's this other use case that this technology is also used for. And you didn't ask about it at the beginning, but here are these other features that we can help you with. And if you provide that level of support, then you can, achieve your goal of integrating into the process, the legal processes of the firm you're selling to. And that doesn't mean that necessarily that you're becoming a consulting firm in addition or instead of a technology company. I understand people want to be technology companies, not consulting firms, and there are reasons why that, and maybe reasons for the other way around too. But even if you don't want to become a consulting company, you just want to remain a software developer, technology vendor, you still have to provide the consulting expertise that's needed for people to have a happy outcome with your technology. So you cannot overlook that. And whether that means having your own team of consultants that are within your firm, or hiring a trusted consulting service that you partner with, that you collaborate with, so they are familiar with your technology, so that they can be your representative within the firm. However you do that, if you want to avoid the situation that your technology gets pigeonholed for one specific use case and isn't utilized across the firm for multiple use cases, then I think you need that sort of personal support.
Right. When you were explaining this, I could draw a parallel with the fintech industry. Like you mentioned, legal teams or the legal departments are not supposed to have that level of tech in their services. So it's not, and as you mentioned, it wouldn't turn them into a consulting, like if you primarily want to be a software company. So the parallel that I was coming up with in my mind is that how, for example, banks work with finances, right? But over the last decade, we have seen companies like PayPal, Razorpay integrate the tech with their services, and now we are so heavily dependent on all the tech that acts as a payment orchestrator. It's something we cannot even imagine going back, right? The adoption happened that well. I think similarly that the same case applies to the legal as well. Like once the legal industry starts adopting it, we will become so heavily reliant on the technology that there is no way of going back. And what as founders we need to do is, like, people who are working in this space, is that uh, just give them the technical support or the support related to the technology. And technology is not a one time product, right? As you mentioned, there is always ongoing transition support that's required as part of the service and to facilitate or enable the product. So I think this is very important, and we have seen this happen with the fintech industry. So if we draw a connection or a parallel with the legal, I believe what we are necessarily saying is that it's very similar. It's just a matter of time that legal also becomes dependent on tech, and legal tech becomes the new thing that everyone that is selling in the market like hotcake.
Yes, and I think that's a very good point. And I'd add, going back to another point you made earlier, which I think is important, is if you look at the fintech industry, there are still people working in the fintech industry, right? The technology didn't put them all out of work. And the same with lawyers. The technology isn't going to put them all out of work. Ideally, it makes them happier, because instead of doing these mundane, repetitive tasks that the technology can do, they're actually doing the higher level legal thinking that they probably thought they would be doing when they applied to law school. And they're able to achieve greater wins within their firm or for their clients. And, the technology can help them be the hero. It's not going to replace them. So positioning the technology in that way that it becomes, a tool that they would not want to, go into battle without, is a way to integrate it in a way that, you're helping them achieve success. You're not trying to replace them. And going in there with that kind of mindset and that kind of message will be more successful than trying to scare the attorney that if they don't adopt it, something bad's going to happen. I mean, I've seen the fear messaging, and the fear messaging just doesn't work. People just don't buy it.
Right. This is such an interesting topic that honestly I could go on hours and hours on this, but I will quickly come to my last question, without which this discussion is it wouldn't be complete. So no discussion related to legal tech product is complete without talking about data security and compliances, protecting the confidentiality, because by nature of the work that lawyers do, we do not even convert documents from PDF to Word just for the fact that the data will be taken by a third party website, right? So we are extremely mindful and vigilant when it comes to protecting the sensitive data that we work with. So in such a scenario, tech is something, especially artificial intelligence, is something that works by feeding on data, right? Is what my understanding is. So it comes as a contradiction. A technology that works on data have to be extremely mindful about the data that it is accessing. It is not like any other data that we can keep feeding into the artificial intelligence and it can come up with it. So this is really a point that I have always thought about, that how do legal tech work, or how do they improvise on the services or the products? Because one of the points that the lawyers have to be mindful of is how to protect the sensitive information and the confidentiality of the data that is being accessed. So I am very clueless as to how do you think this gray area should be navigated?
Yeah, well, as you said, it's a very important question, and it's a question that I think most people recognize as important, but a lot of people also don't want to think about it because it is so difficult.
It is difficult, yes.
And there are multiple standards, multiple issues, multiple controls, and so on. And it is a difficult question, but it needs to be put front and center, because it just has to be addressed, because the risks associated with lack of control on your data are just so great, especially dealing with the sensitive data that lawyers are dealing with every day. So the first step is just recognizing that you have to address it up front. And you have to address it at every step of the way, even going back to the design of your technology, thinking about where that data is going to come from and where it's going to go. Or is it a cloud-based application? And how are you going to handle data that's in the cloud, and so on? Or is it going to be an on-prem solution, and so on? All those things, way back at the very beginning, you have to be thinking about these compliance and security issues and sort of design it into the product so that both you're more secure, and that if you're audited along the way, you have a good story with ideally a security expert who can tell you the software was developed in accordance with these standards to ensure that it was developed in a secure way, and that in the end, in practice, it would meet the relevant security standards. That's sort of conceptually, but in terms of addressing compliance issues once you have a product, I think there are a few things. One is understanding the operative standards, and this is a matter largely of research, understanding whether it's GDPR, SOC 2. In the US, there's CMMC, which is a Department of Defense standard, HIPAA, ITAR. There are a range of different standards and compliance regulations that you may have to meet depending on the type of data you're going to be working with. So you should be thinking, again, going back to the beginning, how your application is going to be used and what standards might be implicated by the use of that technology. A second area that you need to be aware of and investigate is the data itself for any given client. I've often seen clients be very surprised at what's in their data. They may say, oh, my data doesn't have any credit card information in it. And then, oh, well, what about this? Oh, I never would have thought that. Or I never would have thought this health information is in there. And now the health is in there. And so you have an obligation to protect it under regulations that apply in the US, and I'm sure in India and other countries as well. So understanding what's in your data so that you're not surprised is very important, because that will tell you which standards may come into play. A third is having access to the right kinds of expertise. These are very often very technical issues. There are people specialized in this. And so whether it's a consultant or bringing someone in-house, you need to have that person on board. And as I've said more than once, ideally, as a vendor, you have that person on your team from the outset. So that person, that security is built into the product. It's not an add-on at the end. It's not an afterthought. And the other thing I would add is don't narrow your focus to how your application is being used today. Its use may grow, and you may be dealing with other data as more use cases are found for your application, as your application becomes more of a platform for other applications. So, have that sort of longer term vision as you're thinking about the security issues and compliance issues you might have to deal with, so that ideally you kind of pre-qualify your software for meeting those standards further down the road. And then the last point I'd make is to remember that these security and compliance issues are something that everyone in the organization has a stake in because they're so important. Often they get sort of shifted over to the security and compliance person or the security and compliance group. But that, everyone needs, whether it's legal, whether it's, the CEO, the CFO, they all have to know because they're all working with data all the time. And these people need to be working with the security and compliance people all together so that they can be giving feedback to the security and compliance group, and the security and compliance group can be communicating to them what needs to happen. Because if everyone has visibility about the requirements and what should and shouldn't be happening, you're more likely to avoid a breach that could be, depending on the nature of it, it could be very serious and very bad for the company. But if you have your compliance group just sitting over there doing their own thing in a little bubble, that's when other people are going to start doing their own things and think that security and compliance is already taking care of it. And pretty soon they're doing things they shouldn't be doing, and data's going places where it shouldn't be going. And that's not a good thing.
Right. It's absolutely very important to be mindful about the compliances. And when you were explaining, the process just sounded easy. The questions I had in my mind kind of like, it's a very tight scope where you have to be very mindful while walking the road, but it's not something that is not doable. And I was not planning to ask you any more questions, but there is one question that I cannot not ask you is, in your experience of working with all the legal industry and in the intersection of law and artificial intelligence, have you seen any reluctance on the part of the industry to share this data? Because from what I know, lawyers are extremely protective about the data they are working with. So what is the practical scenario like? Is this a roadblock that the founders might face going ahead? How do they navigate that? Like, how do they convince the industry to share the data while assuring them that they will be compliant with all the regulatory compliances?
Yeah, it's a good question. And I think usually it's a negotiation, sort of, one client, may be more risk averse, and they may say, my data, I've had, clients say it cannot, go abroad. It has to be used within the country. It cannot be used for any purpose other than this particular litigation, and so on. Even in cases where it had to be segregated, on separate servers, and there was a special team of people that they were the only ones authorized to work with that data. Other clients have been, more, liberal, if you will, in terms of how the data would be used. Always, of course, being protected, but, less restrictive in terms of, only this team got it, and so on. At the same time, we would, as a company, default to the more secure scenario, and, reassure, because you want to be in a position that our default practice is the most secure. And then if someone, would allow us to use their data, for example, for research purposes, in some limited way, and would of course destroy the data afterwards, then all the good. And they may get some benefit from the innovations we are able to make on the basis of using their data. And maybe, that translates to them into, a discount on some future offering or something like that. You can work it out that way, but you want to present yourself as, in the absence of any, other requirements, you're going to default to the most secure method, and then you can negotiate from there.
Bruce, the reason I could not stop smiling throughout the answer is because I have been on the other side of the table, where anytime data comes up, we become very, vigilant,
Yeah.
adding 10 exceptions, caveat that this cannot be used for this purpose. So it is so relatable, and I myself has done that as a lawyer, so I understand that this is something that is, but as you mentioned, it is not something that is a roadblock per se, but rather something that can be worked around by gaining the trust, showing compliance. It's a negotiation again, right? So it's a two-way street where it works both way. And we had a very insightful conversation. We have covered a lot of grounds today, and I'm really glad that you have shared your hard and earned insights that you have accumulated over 2 decades. That's a very long time of working, and I'm really, really glad. I would like to thank you. However, I would request you to give one tip holistically to all the founders who that they can, what is one mantra that they should be carrying with themselves while traveling from the journey, like while working the journey of conception to turning it into a viable product, to making the law firms or the legal industry adopt the product, and also complying with so many regulatory and statutory compliances that comes with it, this being a highly regulated entity. So if there is one thing, or maybe a couple of them, that the founders should stick to no matter what, that is the their go-to strategy or the mantra, what would that be? And we would conclude with that.
Sure. Well, the one word I would point to is a word that both you and I have used several times throughout this conversation, is trust. And I think as a developer of a technology, if you keep in mind that goal of trust, and different types of trust, but trust that you understand the client's problem, trust that your technology works and is effective at meeting that problem, and trust that you will stand behind that technology when push comes to shove and someone needs to defend the technology. If you keep that in mind, keep that, just if nothing else, just keep that word trust in mind, and that's what you want to be. You want to be a trusted partner. Even going back to our last conversation about security of data and so on, and security requirements, if you build a relationship and you build that trusted relationship, everything else becomes easier, and you become a partner with your clients. You develop that long-term relationship, and that's when you go from short-term transactions to long-term growing predictable revenue, which is where you want to be as a technology company. So that's a long way of saying just the one word I would say would be trust. Keep that. That's your sort of lodestar you always should keep in mind again in everything you do.
I absolutely love that. Me being on the other side of the table, after having an hour-long conversation with you, I am convinced as to why. I mean, you're really good at this, right? That I am convinced as to how this can be navigated, why the legal industry should be adopting more, tech products, and it's amazing. So thank you, Bruce, for joining us. Thank you to our listeners.